Hello, my name is Deborah Gonzalez. I'm the director of the Immigration Clinic at Roger Williams University School of Law. I want to thank the Brown Human Rights Asylum Clinic for, again, inviting me to speak to you today about asylum law and the important work that you all do when you do evaluations and you volunteer to take on cases. I can't express to you how important the work that you do has made a difference in the many cases that I and that many of my colleagues have had when we've used your services. The purpose of mental and physical evaluations is to corroborate the applicant's story and to meet the burden of proof of persecution, to assist in the court in understanding how the mental and physical injuries have affected the applicant as it relates to well-founded fear of persecution. So I want to share my screen with you, so excuse me as I do this, because this is the first time I'm actually recording, so I hope I don't mess this up. So here we go. I'm going to share my screen. Oh, here we go. Good. It looks like I'm doing okay. I think I'm doing okay. Let's go from the beginning. Okay. So this is me. This is what I do. And so I guess we'll keep going here. So, why are you guys important? I mean, again, you corroborate the applicant's story. You corroborate the persecution to the applicant. And really what you're doing is educating the court as to how the mental and physical illness is really related to the persecution that the client suffered. So providing your expert opinion is incredibly important in terms of whether or not an applicant could win or lose their asylum case. So a person who is applying for asylum needs to be inside of the United States and is unwilling or unable to avail themselves the protections of the country due to a well-founded fear of persecution on account of one of the 5 protected grounds. So that's on here. But the law requires that the applicant meet the definition of a refugee, which is a person outside of the country and unwilling or unable to avail themselves of the protections. The persecution doesn't need to be by a government official. It can be by anyone that the government is unable or unwilling to control. And so all of the terms that you're seeing here on this screen have special meaning and have been defined by the court. Now, you don't need to memorize them, but you certainly should understand that unless the applicant can meet its burden of meeting every term that I've just laid out here on the screen, that it's not going to be possible for an applicant to be granted asylum. Okay, so I want to talk to you a little bit about the bars, right, for asylum. So when an immigrant comes to the United States and they're seeking asylum, they must apply for asylum within a 1-year period of entering the United States. Now, many clients and many immigrants who apply for asylum do not file within the 1 year for a variety of reasons. Either they didn't know they needed to file, or they didn't think that they had an asylum case, or they couldn't afford an attorney, or it might have been due to a mental or physical impairment, which is why your role is so important. A client may not have filed due to a mental breakdown or some other physical issue that might have prevented the person from applying previously. Now, in the past, I've asked medical professionals for their opinion on whether the inability to file asylum was related to trauma that the person might have experienced. This requires the medical professional to document and discuss within the report how the trauma affected the applicant's ability to file within that 1 year filing period. And also to address the client's misinterpretation well, strike that. That's not what I mean to say, but I guess what I'm getting at is when you're applying, when an applicant is applying, they must apply within the 1 year but sometimes they don't for the reasons I've just laid out. However, attorneys may still be able to file for asylum if they can show there's an extraordinary circumstance that delayed the file, and that can be the physical or the mental trauma that the client has actually suffered. It's important that the evaluator talk about the severity of the harm, the need of ongoing care, and the impact that physical or mental injury would have on the client if they had to return to their home country. And again, if well documented by a medical evaluator's report, we may be able to convince the court that the client should be eligible for asylum, notwithstanding the 1-year bar, because of the mental or physical injury. You'll see on the screen that it says that if there's a change in circumstance that materially affects eligibility, that's generally related to issues relating to country conditions. Other reasons why someone may be prevented from applying for asylum is, one, if the person applied for asylum and was already denied, if the applicant was also the cause of persecution of others, and we see that a lot for folks who may have worked in the military in their home country and caused persecution because they themselves were being persecuted by the government, but the moment that person causes persecution on someone else, they're ineligible. It could be that the client resettled in a third country, or that the client was deported and then tried to re-enter the United States. So after a re-entry, the person would also be ineligible for asylum, but would be eligible for withholding of removal. And I'll talk about that a little later. Also, if the person is going to be a threat to national security, they're not going to be eligible for asylum. So I want to talk to you a little bit about the asylum process, right? So there's 2 ways in which a person can apply for asylum. They can either do it affirmatively, meaning they've never had any contact with immigration before, and now, you know, they have seen someone or have decided that they qualify for asylum, and now they're going to immigration, what we call an affirmative file, affirmatively, and saying to immigration, I'm here, I've been persecuted in my home country because of some characteristic that I possess, and my class of people is protected under the law, and so I want to apply for asylum. When an applicant is applying for asylum affirmatively, they would prepare the asylum application along with a detailed affidavit from the client as to the circumstances that led to the persecution and then the harm that was caused to the client, and talking about the persecutor and country conditions and that sort of thing. It's at that time that we also submit the medical evaluator's evaluation talking about what the mental harm might have been or is, and also any physical harm that the client might have had. If it is an affirmative filing, then an interview is scheduled with an asylum officer, and the asylum officer, and during those interviews, the only person that testifies is the client. So the expert does not testify in those instances. The only thing they submit is their declaration, and we usually submit that with the medical evaluator's curriculum vitae. So once an interview is conducted, if the matter is approved, then that's it, right? The person is granted asylum and they'll get their green card within a year. If it is not approved, it's not necessarily denied either. The matter is then submitted to the immigration court and the person is placed in removal proceedings. Now that's a double-edged sword there, because now the client has the ability to apply for asylum a second time. So there's like a second bite of the apple, if you will. But the flip of that is now the client has to relive that trauma by telling the story again in immigration court in front of the immigration judge about what had happened to them. Also, going into immigration court means that the person is going to be cross-examined by the attorney for the government. So that's also a downfall. In immigration court, we do ask, at least I always do, if my medical evaluators are willing to testify in court. I said to you there were two ways of applying: affirmatively, right, going to the asylum office, or defensively. Now, if the case is not approved at the asylum office, it can get referred. But in many instances now, with folks that are coming in through the border, we're seeing people put in removal proceedings almost immediately. They apply for asylum at the border, although under this administration, things have changed considerably. But, you know, they'll apply for or seek asylum at the border, be placed in removal proceedings, and now they're filing for asylum defensively, right? Meaning that immigration wants to deport them, and they're defending themselves by saying to immigration, hold on a minute, I've been persecuted in my home country, I want to apply for asylum. The process in terms of the documentation that's being submitted is the exact same. The difference when they're filing it defensively, when they didn't have an opportunity to file it affirmatively, is that now that they're only going into the immigration court and really only telling that story one time to the immigration judge. So there's only one bite of the apple. Again, they're cross-examined by the trial attorney, and we do ask that experts testify in court. That always makes the process a little bit better. You know, I wrote here that the client at a hearing has to retell the story, but now they're subject to cross-examination and harassment by a government attorney. I mean, not every client is harassed by a government attorney. That's me being facetious about this process. But in many instances, I think, you know, the trial attorney's job is to discredit the client, and the only way to do that is to get the client to change the story around or say something, which is why it's incredibly important for the medical evaluator to really be detailed in their report, right? So you want to make sure that if the client is telling you, well, you know, I was persecuted by whoever, and I was so afraid to leave my house that I didn't leave my house for a year, except to go to work and school. But now the evaluator on the reports writes in one section that the client was going to work in school, and in another section that he didn't want to leave his house for a year. That becomes confusing to the court. So I always ask medical evaluators to really be detailed in their reports. So if a client is telling you, you know, I was persecuted, I was so scared I didn't want to leave my house, but I was still working and still going to school, then how did that play out? So, you know, I left my house at 8 in the morning. I had to be at work at 8:30. I gave myself just enough time to get to work. I didn't stop anywhere before work. I didn't stop anywhere after work. When I went to school, I did the same thing. On the weekends, I never left my house. My family was doing, you know, the grocery shopping. I was, you know, not attending church at the time. My family would come see me at my house. So, right, just kind of being a little more detailed in the report so that there's no ambiguities in the medical evaluation, and so that the client can better explain that. Because once they've explained that to you, that's like the first time that the client has said to someone what that detail looked like. And we might talk about this a little bit later in this presentation, but I just kind of want to get that out because I want to make sure I don't forget to say this. So other forms of relief in addition to asylum. So asylum grants the immigrant a green card. Withholding of removal does not, right? And I said to you, people who have left the United States and now have come back in and are seeking asylum are not going to be eligible for asylum, but are eligible for withholding of removal. Withholding of removal is a similar process, but the burden now is higher. So in asylum, the client only needs to prove that they were persecuted in the past, and the court makes this presumption, or the law makes a presumption that there'll be persecution in the future. With withholding of removal, that's not true. The client not only needs to prove that they were persecuted in the past and that that persecution will continue in the future. Also, withholding of removal doesn't grant a person a green card. It only allows them to stay in the United States with employment authorization or until such time until such time as circumstances change in the home country. So I apologize for my phone is ringing, I'm sorry. Okay, so Convention Against Torture, again, is a higher burden. However, now the person doesn't have to meet the definition of a refugee, right, which is that person who is unwilling or unable to obtain the protections of the home country due to a well-founded fear of persecution on account of one of the 5 protected grounds: race, religion, national origin, political opinion, or membership in a particular social group. Convention Against Torture now just requires that the applicant prove that they were tortured by a government official in the home country. Not everybody's eligible for Convention Against Torture either. Convention Against Torture means a removal order, but the government won't remove until circumstances change. So it's really a deferred deportation order, right? And I use removal and deportation in the same context, or you know, I use them interchangeably, meaning that they mean the same thing. Okay, so again, who can apply for asylum? The person needs to be in the United States. They have to be at our borders, whether or not they have proper documents. Now, some of you may have heard that the Trump administration is trying to change these regulations. I, you know, notice and comment just went out over the summer of 2020. I'm not sure when you're watching this video, but I'm hopeful that that's not going to happen. And I'm also hopeful that he's not going to win re-election. Okay, so I want to talk to you a little bit about what these terms mean, right? We've talked about that a person applying for asylum needs to meet the definition of someone who is in their home country unwilling or unable to seek the protections of the home country due to a well-founded fear of persecution on account of one of the 5 groups. And so the term well-founded fear on account, well, let's start off with the term well-founded fear, right? So, but all of these terms, I suppose I want to say to you, is defined by the Board of Immigration Appeals, which is the appellate, is an administrative court, but is the appellate court for the immigration court. And these terms are defined by matter of Acosta, and the citation is 19I&NDEC 2011, parentheses, BIA 1985, close parentheses. And the court, the BIA, defined well-founded fear to require that the applicant prove that he or she has felt the fear to him or herself, and that another person in the shoes of the applicant would likely feel or would feel the same fear that the applicant felt. So they also need to prove that the person possesses, right, that the applicant possesses a characteristic that the persecutor is looking to overcome, that they have been threatened by the persecutor, and that the persecutor is looking to do the harm because the person possesses this characteristic. So when we're thinking about, let's say, you know, let's talk about membership in a particular social group, which is how most people apply for asylum. And we'll talk about what the term membership in a particular social group means. But let's say we're talking about a Mayan person from an indigenous person from Central America, Guatemala, Honduras, wherever. And now that person has been persecuted by the Ladinos in the home country. And say that this indigenous person has been persecuted by someone who owns their land because they don't like that this indigenous person wears certain clothes or prays to a certain god or eats a certain food or looks a certain way or speaks a certain language, right? So now the indigenous person needs to prove that this Ladino person has persecuted them, has either caused mental harm or physical injury of whatever nature, and that the applicant felt the fear to himself, meaning that the fear couldn't have been, or the threat couldn't have been to a brother, with the exception of children. So children can kind of infer that fear from a family member, but not adults. So let's say we're talking about a grown man, for example, someone over the age of 21. They can't say that they're in fear, that they have a well-founded fear if they themselves have never been persecuted, right? So the fear needs to be genuine, subjective to the person, because now they themselves, the person, has been threatened because that Ladino person came to their home and caused whatever harm, but that also other indigenous people in his shoes would have felt the same way had they been in his possession, right? So the fear, again, needs to be a well-founded fear that the person has been persecuted. Anybody else would feel that way, that the person possesses a characteristic that the persecutor is trying to overcome, and that the persecutant has the inclination to try to cause harm because of this characteristic that this person possesses. Okay, so right, well-founded fear of persecution. Again, all of these terms mean something. They're defined in matter of a constant by the Board of Immigration Appeals. Persecution is defined as the threat to life or freedom. It's the infliction of suffering upon those who differ in a way that's regarded as offensive to the persecutor, right? So this could be, right, the threat could be confinement, it could be torture, it could be beating, it could be rape, it could be electric shock, forced abortions. It could be psychological, such as witnessing harm to another person, particularly as it relates to kids. It could be emotional abuse by a domestic partner. The threat or harm, again, must be on the individual himself. And it can't just be general threats. So it can't just be that they've received a letter by someone they don't know that says that, you know, if they do a certain thing again, that they're going to be beaten. So that generally doesn't work. So say, for example, a gang member lives in a neighborhood and they've been extorting from some of the neighbors, and now that person feels fear that they're going to be extorted too, but never really has been extorted. There's really not persecution there. The court will not find persecution because the person hasn't yet been extorted. However, once the gang member starts to extort, then there'll be some persecution there, although gang cases are kind of funny. Another example is to say maybe the applicant's brother is part of an opposing political party, right? And that the brother has been targeted and beaten, and now the applicant fears that he will be targeted and beaten. Again, right, that's not going to work. It needs to be harm to the person himself. Again, details of the infliction and the harm matter. So, you know, for example, if a client is tortured for being gay in Cuba, he's arrested and detained for a week, and now he's applying for asylum. He tells the evaluator that he's afraid to go back. He was afraid to leave his house again, but then, you know, went to work. You kind of need to spell out what that fear was. What was the persecution? How exactly did that infliction occur? You know, if the person was being persecuted for being gay, how did the persecutor know that he was gay? Was he attending a bar? Was he at, you know, a pride rally? What exactly was that person doing that would have given the persecutor the knowledge that that person was gay? What was the characteristic that was shown that led the persecutor to know that the client was gay? And then what was the infliction, right? There was detention. Okay, did anything occur during that detention? Where was the client detained? Was he being served food? Was he being served water? What did that detain? Did he have access to a phone? Could he call a family member? What did that look like? If the person was released after the year, how did that work? So if they had been released after the year, you know, and they were afraid, what was happening during that year? Why didn't the persecutors come after them again? So really kind of breaking down and telling the whole story in the report is going to be incredibly important. And so, you know, again, as if a person is applying for withholding of removal, and say you have a client that was persecuted for being gay, right? So the person is gay, they're from Cuba, they were detained, and then they were in fear of leaving their house for a year before they came to the United States. In an asylum case, they only need to show the past persecution, but in a withholding case, they need to show future persecution. So it's important that the evaluator be in touch with the attorney and ask the attorney, what is it that the attorney is looking for? You know, which application are they filing for? Are they filing for asylum, or are they filing for withholding? Do they need to show only future persecution or past persecution? Because we need the attorneys, we meaning the attorneys, need the medical evaluator to be able to explain to the court what that future harm is going to be and how that persecution is going to play out should the person have to return. So for example, if you had this Cuban client who was gay, who had been detained for a year, and now they're filing for withholding of removal, and the attorney needs to prove future persecution, it's having a conversation with the client of, if you had to go back to Cuba, what would that look like for you? You know, would you continue to be persecuted, and why the person believes that? Now, certainly the attorney is also going to do that, right? But to the extent that the evaluator can get that out there and then talk about how the mental or physical harm will continue should the person have to return to the home country, that's going to be incredibly helpful. Okay, so the persecution needs to occur because of the characteristic that is possessed by the applicant. So again, it's important to document that there is a characteristic that the client possesses. So earlier, you know, I talked to you about indigenous people, you know, and how there are many accounts of indigenous people being persecuted on account of their dialect, on account of the way they dress or the way they speak, even when they try to speak Spanish if they're coming from a Central American country. So documenting again in your report those characteristics are going to be important, but then also documenting in the report, to the extent that the client tells you the story, whether or not that persecution occurred because of the person's characteristics. So I had a client who, she was Mayan, Quiche, and you know, she was a young girl living in Quiche in Guatemala, and her parents had bought land from these Ladinos, and they required, as payment for the land, that she serve the family. And so when she went to serve the family, she was beaten for not making the tortillas the way the woman of the house wanted, or the owner of the land wanted the tortillas to be made. She was beaten because she had long black hair, and the land owner didn't like that, and in fact cut her black hair, which to Mayan people is traumatic because their hair to them has some significance. And so it was important during the course of her case, when she did her evaluation, to be able to tell that story. In that case in particular, that young lady had been tortured so significantly by the Ladino family that she wouldn't tell me what had happened, because she had normalized the situation in her mind and didn't think that that rose to the level of torture. And it took the medical evaluator through Brown for the medical evaluator to get information from her that I was not able to obtain in a span of, I don't know, 5 or 6 years that I had been representing the client. So in many instances, you all have the ability to capture information from a client that I, as the lawyer, just don't for some reason don't have the ability to capture. So really kind of breaking down those details in your report, in your evaluation is so important, because that is how we can make the connection that the well-founded fear of persecution is on account of, is because of the characteristic that this person possesses. In many instances, that is done through the work that you all are doing. So thank you again. Okay, so I want to talk to you about the protected ground. So, right, I've said that it's a well-founded fear of persecution on account of one of the protected grounds: race, religion, nationality, political opinion, membership in a particular social group. I mean, race, religion, nationality, you could probably define those yourself. They're, you know, pretty standard definitions as it relates to asylum law. Like race relates to the person's ethnic group, and religion is what's the person's religious beliefs, and nationality, what country does the person belong to. Political opinion, right, is what activities, what political beliefs, what related policies does the person believe in and has fought for in their home country. I had a client who was being persecuted by the government in Guatemala because she was looking to make voting in Guatemala much more transparent than it is today. And so she was being persecuted because of her political opinion, right? Kind of getting out those details as to what was her involvement, what position did she have, how often did she speak out, how did she know that the persecutors were after her because of this political opinion. So kind of fleshing all of that information out was incredibly important. Membership in a particular social group is probably the most common of protected grounds that people apply for. I mean, race in Central American countries, when we're talking about an indigenous person. Religion, not so much in Central America, but could be something that would be a grounds for asylum in, you know, say an African country or Asia or someplace like that. You know, political opinion could be just about anywhere, I suppose. But membership in a particular social group has its elements in and of itself. So it requires that the applicant prove, in order for an applicant to prove that he's a member of a particular social group, he has to prove that the group is socially visible, that is recognized by their community, and that it has an immutable characteristic that it can't change or shouldn't be required to change. So, you know, you could say that an indigenous person is a member of a particular social group, right? The immutable characteristics is their culture. You know, they are known in the community as someone who is a member of that indigenous group, and the community recognizes them as that. But it could be a variety of things. In the past, I've argued that members of families are members of particular social groups, right? For example, I'm a wife. I'm married to my husband, Roberto. I carry the last name Gonzalez. And let's assume that maybe people don't like me because I'm married to my husband. Maybe it's because, I don't know, maybe it's because my hair is brown and they wanted me to have blonde hair, and now I'm married to my husband. Right, the familial, that's not a great example actually, but let's talk about family members, right? So if I am a member of a group, and let's say, you know, my husband has done something to someone that they didn't like, and now they want to take it out on me to get to my husband. And now I am being persecuted, so that now I have been stopped on the street and detained and whatever, right? The immutable characteristic that I have is my marriage to my husband. I've been married to him. I cannot change that, right? Even if I got divorced, it doesn't take away from the fact that we've been married. So my past experiences are immutable characteristics that I possess, that anybody would possess. And they're recognized by the community. Most people know I'm married to my husband. people who know me, who recognize me in my community, all of my neighbors. I'm a lawyer. The people in the legal field know I'm married to my husband. He happens to be a lawyer too. So those are a couple more elements that an applicant has to prove in order for them to be able to seek asylum under the protected grounds of membership in a particular social group. Again, this is not something that the medical evaluator should be figuring out. It's not for you to figure out what should be the membership in a particular social group. The attorney should have done that when they met with the client and referred the case to you. So again, working in tandem with the attorney on the case to say, you know, do you have a theory of the case? What's the theory? What is it that you plan to argue? You know, what's the protected ground that you're seeking? Race, religion, nationality, political opinion, or membership in a particular social group. And then what do I, medical evaluator, need to give you, attorney, in order for you to be able to meet this burden of proof? And again, you know, you're not going to do that by yourself, but certainly corroborating the story in your medical report helps the attorney when the client testifies to that, right? So to the extent that the client says to you, well, you know, I was married to my husband, and he was you know, the previous political party, and then when the new political party came in, they sought to, you know, really kind of attack and persecute all of us who were from this other party. And because my husband was involved, they started to attack me. And now, you know, I've been beaten and you know, kidnapped because they wanted to get to my husband, right? The family unit is the membership in a particular social group. And attorneys are really great at coming up with social groups that they've devised in order for it to work. Do speak to the attorney, because the attorney should have that information for you as to what it is that the membership of the social group is going to be. Okay, so, right, I've been talking to you a lot about asylum cases, but asylum cases isn't the only place that attorneys need your help. So in VAWA cases as well, where the persecution by the spouse. So a VAWA case is a form of relief wherein an immigrant can seek their green card if they've been battered by a United States citizen or a lawful permanent resident, USC LPR, spouse, and the harm can be both mental or physical. And so, you know, getting an evaluation about, you know, what was the abuse, particularly as it relates to mental domestic abuse partners that are just incredibly, or say hurtful things to domestic partners, could cause for a VAWA case. Victims of crime is a U visa, right? People who have been victims of crime are eligible to obtain their green cards through a U visa. They need to prove that they've been the victim of a crime, that they've suffered a physical or psychological harm as a result, or injury as a result of this crime that occurred against them, that they are cooperating with the prosecution of the perpetrator, and that a law enforcement agency will certify that the incident occurred, that the client was the victim, and that they're cooperating. Medical evaluators are incredibly important, particularly if the person has had psychological effects relating from this incident. So for example, I had a client once who she received a mail box from the UPS, and she opens up the box and it's cocaine. And now she sees that there are people kind of walking by her house. They've knocked on the door. She's from Guatemala, which exasperates her fear of gangs and threats of violence. And so she becomes incredibly depressed and anxious. She won't leave her house. She calls the police and says, oh my God, I received this in my house. Now she's worried that the police are going to charge her. And so we sought to file a U visa. And although there was no physical harm, she was certainly psychologically harmed by this perpetrator who we didn't know who it was. But certainly there was a crime that had been committed, right? This drug trafficking on her. She was, and the crime has to be a qualifying crime too. So not a great case, of course, I'm not saying that it was, but what I'm getting at is how important medical evaluations and psychological evaluations are to a variety of cases, not only asylum cases. T visas, which I've not done a whole lot of, are visas that are granted to victims of trafficking. They need to be present in the United States and suffered extreme hardship. That could be either sex trafficking, slavery, employment, forced employment, that sort of thing. And the person needs to show, again, that they've cooperated with law enforcement. Another one that's not listed on here, I'm sorry, I just thought of it as we're here right now, is cancellation of removal cases when a person has been living in the United States for a long period of time. In many instances, there'll be an evaluation that needs to be done on a family member because a person who is undocumented can get their green card if they can show that their family member will suffer hardship. And I've had many cases where, my client, the undocumented person, will be married to a spouse who now relies heavily on that spouse to take care of the kids, to provide income. Maybe the spouse has an elderly parent and now the immigrant spouse has kind of like taken on everything in the household, and the US citizen spouse is now suffering from anxiety or depression for the threat that the undocumented spouse is going to be deported. A mental or psychological evaluation is incredibly helpful when we have cases like that. So there's a variety of ways and a variety of applications in which, medical evaluators can really help an immigration attorney to build their case. So this is being recorded, so I can't take any questions now, but I'm happy to take any questions. Here is my email and my phone number, and I'm happy to answer any questions that you may have. Thank you again so much for having me, and I really always look forward to working with the Brown Human Rights Asylum Clinic. Thanks again.